Doctrine of ultravirus. Meaning of ultravirus, ultra and virus. The term ultra means beyond and the term virus means powers. The term ultravirus means doing an act beyond the power. Categories of ultravirus acts. There are three categories of ultravirus acts. First, an ultravirus act which is done by director, and act ultravirus the article of association, and third one is an act ultravirus the company or memorandum of association. The object clause of the memorandum of the company contains the object for which the company is formed. An act of the company must not be beyond the object clause, otherwise it will be ultravirus and therefore void and cannot be ratified even if all the members wish to ratify it. This is called as the doctrine of ultravirus, which has been firmly established in the case of Ashbury Railway Carriage and Iron Company Limited versus Ritchie. Thus, the expression ultravirus means an act beyond the powers. Here, the expression ultravirus is used to indicate an act of the company which is beyond the powers conferred on the company by the object clause of its memorandum. An ultravirus act is void and cannot be ratified even if all the directors wish to ratify it. Sometimes the expression ultravirus is used to describe the situation when the directors of the company have exceeded the powers delegated to them. Where a company exceeds its power as conferred on it by the object clause of its memorandum, it is not bound by it because it lacks legal capacity to incur responsibility for the action. But when the director of a company have exceeded the powers delegated to them. Origin and development of ultravirus doctrine. The doctrine of ultravirus has been developed to protect the investors and the creditors of the company. The doctrine of ultravirus could not be established firmly until 1875 when the directors of the Ashbury Railway Carriage and Iron Company Limited versus Hector Ritchie was decided by the House of Lords. A company called the Ashbury Railway Carriage and Iron Company was incorporated under the Companies Act 1862. Its object, as stated in the Memorandum of Association, were to make and sell all land on hire, railway carriage and wagons, and all kind of railway plant, fittings, machinery, and rolling stock. To carry on the business, mechanical engineers and general contractors to purchase, lease, work, and sell mines, minerals, land, and buildings, to purchase and sell as merchant timber, coal, metal, or other materials, and to buy and sell any such materials on commission or as agent. The company entered into contract with another firm of railway contracts to finance the construction of railway line in Belgium. This contract has been ratified by the special resolution of the company. Later on, the company repudiated the contract as an ultravirus. The firm of railway contractors brought against the company for damages for the breach of contract. It was held that the contract is ultravirus, so the contract is ultravirus. Effect of ultravirus transactions or acts. First one, injunction against the company. Personal liability of directors to the company, personal liability of directors to the third party, ultravirus contracts are void. Injunction against company. In case any ultravirus act has been done or is about done, any member of the company can obtain injunction from the court. He may obtain a court order restraining the company from proceeding with the ultravirus act. Personal liability of directors to the company. The director of the company are personally liable to the company for ultravirus act. It is the duty of the director to see that the company's capital is used for the legitimate object of the company. If the company's capital used for any other way which is not connected to the company's object, the director will be personally liable for the same. liability of directors to the third party. The director of the company are personally liable to the third party as they exceed their authority to doing the ultra-vires act. It is the duty of the director to act within the scope of authority. If he exceeds the authority, he will be personally liable to the third party. If any loss has been suffered by third party, then also the liability of directors are raised personally. Ultra-vires contracts are void. A contract which is ultra-vires the company beyond company's power is void and without legal effects, company is not competent to enter into such contracts. It may be noted that the ultra-vires contracts cannot be become intra-vires by subsequent ratification. Though the ultra-vires acts are void, but the company is entitled to bring a legal action for the protection of its property even if it acquired by unauthorized act and expenditure. Exceptions to the doctrine of ultra-vires. There are, however, certain exceptions to this doctrine which are as follows. If the company acquires some property by ultra-vires expenditure, the company's right over the property will be protected. Second, if the company acquires some property under an ultra-vires contract, the same can be recovered from the company if it exists and it is traceable in the hands of the company. If the company takes an ultra-vires loan and uses it to pay its own debt, then the money lender gets the right of the creditor whose loan has been paid by the company can recover his money from the company. If any company borrows money from the company under an ultra-vires contract, the company has right to recover the money from him. If a director of company makes a payment of certain money which is ultra-vires, the company can be compelled by the company to refunding. The company can be held liable to ultra-vires tort of its employees only if the tort is committed in the course of an activity which falls within the scope of company. Don't forget to subscribe my channel for more videos on law. Like and comment down below for the further videos on law in Hindi and in Gujarati language. Thank you.